Can a corporate entity hide behind its memorandum to escape criminal prosecution for financial scams? If you write a basic textbook definition in your UPSC Company Prosecutor Exam, you will miss out on the top ranks. Welcome to the Constitution Code. I am a practicing bank law officer. Let's put our legal scanner on the bedrock of corporate capacity. The doctrine of ultra vires. Under the Companies Act, any act done by a company beyond the powers explicitly listed in its Memorandum of Association is ultra vires, meaning legally dead and completely void from day one. It cannot even be ratified by a unanimous vote of all shareholders. So let's ask this question: can a company be prosecuted for criminal offenses like cheating, forgery, or money laundering? Old school legal thought said no, because a company has no physical body to go to jail and no mind to possess mens rea or criminal intent. But as a company prosecutor, you must quote the historic five-judge Supreme Court judgment ruling in Standard Chartered Bank versus Directorate of Enforcement. The Apex Code made it absolutely clear: a corporation can be prosecuted and convicted for offenses that require a mandatory sentence of imprisonment. Since you cannot jail a corporate entity, the court will execute the punishment by imposing a heavy punitive financial penalty instead. Furthermore, the court will apply the principle of alter ego to pin the criminal intent directly onto the directors controlling the company's brain. Mastering this distinction is what guarantees selection under the company prosecutor exam. We are scanning one advanced corporate law mechanism like this every single night. Hit the subscribe button to join the Constitution Code. Bypass the coaching fluff and let's change the game. See you tomorrow.